You are Mr. Scott Sanders.
So,
Mr. Sanders, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 25th, 2025, officers initiated a subject stop at a Walgreens on East Mount Houston Road, Harris County, Texas. Officers observed a defendant sitting outside the entry holding a brown cardboard sign, panhandling. Officers approached the defendant.
Notice how the defendant immediately says, "I'm leaving." "I'm leaving," classic sign. They know they're already in trouble. But here's the legal kicker. Once police initiate contact, simply leaving doesn't undo the probable cause. They may already have.
Defendant stated, "Okay, I'm leaving. They told me to leave. I'm leaving. Don't take me to jail." Officers asked consent to pat down the defendant. The defendant consented to the pat down. The officers observed a green leafy substance in a plastic bag located on the defendant's person. The defendant stated he forgot the marijuana was there, but that it was only kush. Officers observed an additional plastic bag containing a green leafy substance. The officers observed the marijuana to weigh 0.045 ounces. The complaining witness was identified by their Texas driver's license and advised that the defendant has shoplifted multiple times and has been trespassed. Complaining witness informed the officers that complaining witness asked the defendant to leave prior to the officer's arrival. Complaining witness advised the officers that the defendant initially left the property. Complaining was unaware of the defendant's return to the store until the officers contacted him outside the store. Officers note defendant's theft case was against that Walgreens and was dismissed. Officer notes that the defendant has been criminally trespassed from the same Walgreens. Officers also noted that they did observe a meth or crack pipe on the defendant's person. The complainant was able to identify the defendant based on the previous mugshot.
Mr. Sanders, I'm going to find that there's sufficient probable cause to go forward with your case.
yes,
Let me provide you a lawyer today so that you can talk to someone about this case. All right. For now, do not go back to this Walgreens. Let's not talk about this case because you have the right to remain silent. I don't want you to say something that hurts your case.
They want to say something about seeking treatment.
Okay. Let me get you a lawyer first and then we can talk about it and we'll try to help you as much as we can. Okay. Vic, do you mind?
Yes, Judge.
Okay. I'm going to have you sign a receipt of Victoria and then we'll have you take your seat in the jury box, sir. Okay.
Right this way. Go ahead and sign for your step, please. Next, Judge, is page 32, Williams.
This isn't just any DWI. It's elevated to a class. A misdemeanor because of the high blood alcohol content. Translation? Not just a slap on the wrist. What do you think? Should higher back always mean harsher punishment? Or is that going to fair?
Come on up.
Good morning, Mr. Williams. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Okay. On March 25th, 2025, an officer was dispatched to Montrose Boulevard for a call for service related to driving while intoxicated. The officers observed the defendant's motor vehicle upon arrival. The officers observed the defendant's vehicle to have major front end damage, multiple airbags reported, and to be leaking fluid. The officer met with the witness who called 911. The witness stated he observed the defendant's vehicle to have struck a light pole. The witness stated that he did not see the actual crash, but saw the defendant back up and start driving away from the crash. The witness observed the defendant drive several hundred feet before stopping due to the motor vehicle being disabled. The witness stated that they observed, the officer made contact with the defendant and an officer observed a strong odor of alcoholic beverages emitting from the defendant's person. The officer also observed the defendant had bloodshot eyes and slurred speech. The officer observed the defendant had trouble maintaining balance as well. The defendant consented to standardized field sobriety test. The officer observed 6 out of 6 clues on the HGN test, 7 out of 8 on the walk and turn, and 4 out of 4 on the one-leg stand. Defendant consented to a breath sample, and which the test readings came back at 0.185 and 0.168.
Any prior DWIs? And then does he have a license?
No prior DWIs, Your Honor, and I'm running that license.
Please. Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail.
His license is eligible. No.
As long as you have a valid license and liability insurance in your name, then you may continue to drive. But if I find that you're using, it's not going to go well and I will revoke your bond and put you in jail. Do you understand? Do you have the ability to hire lawyers, sir? Okay, we will give you time to hire lawyers. So I will first have you go to Victoria, sign a reset. You will then get with Fleischer for your bond conditions. After that, we'll get you out here to hire a lawyer. All right? Please.
This way.
Good morning, Ms. Woods. Ma'am, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
March 26, 2025, in Harris County, Texas. Officer was dispatched to a disturbance call. Officer met with the complaining witness who stated that he and the defendant were in a sexual relationship. Complaining witness stated that he and the defendant got into an argument over the Wi-Fi password. The defendant punched the complaining witness in the face, head, causing pain. The defendant also ripped the complaining witness's shirt, scratching him in the process, also causing pain. Officer observed the defendant to have visible injuries to his face and back.
Do we know whether he wants to have contact?
No, it's not.
He does not want
He
to.
does not.
Okay. Ms. Woods, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. I am ordering you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate this, we will revoke your bond and put you in jail. Do you understand me? You have the ability to hire a lawyer. We can have you fill out an application. I'll take a look to see whether you qualify. Deputy Miranda is going to give you an application. I need to know everything about you, where you work, what kind of money you make, money in the bank, car, what kind of car you drive. And then I'll take a look to see whether you qualify. I'll have you sign a receipt with Victoria. We'll give you the application, then we'll have you take a seat in the jury box. Thanks, Mitch.
This way.
And they're dismissing the felony upstairs, and he's
Change for
doing,
this?
yes, for the probation with TRAS conditions.
Has a TRAS been done yet?
Yes, and your recommended IOP is
Salustrio.
No, Mr. Shh. You have, or you're not you, but your lawyers have worked a killer deal for you today. You speak English, right?
Yes, I do.
Where they're going to dismiss the felony in exchange for your plea on this case. I'm going to tell you now, this is not something that happens very often. So get a clue. Do you understand?
Yes.
The agreement that you have worked out here is you're now charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you have is 180 days in jail to be probated for 15 months. You need to understand that this charge is going to go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. Not only that, whenever you get pulled over, officers, the first thing they do, and the only thing they do when you get pulled over is they look at your record. If they see that you have a prior DWI, if they see that you have a prior felony, PCS, you think they're going to treat you good if they smell anything funky? Probably not. So don't give them the ammo to shoot you with a gun. It is a DW, any prior DWIs? So the agreement is a DWI education class, one victim impact panel, a TRAS, but you have already done it. So the TRAS here is recommending intensive outpatient treatment followed by supportive outpatient treatment. This is what you must do. If you fail to complete these conditions, I will issue a warrant for your arrest. I will put you in jail and I'm going to bring you right back out in orange and we're going to talk about whether you violated you. And if you do, you're looking at 180 days in jail. Do you understand? No drugs, alcohol, random testing, and a guardian and a lock.
He has, we're gonna do the portable, because he's not driving, doesn't have a license.
So be signing an affidavit today promising us you're not going to drive. Mr. Garcia, do not drive. If you want to see me grow horns and a tail, I'm telling you, don't drive. If you want to drive, do things the right way, ask for permission, get a license, get insurance, and then I will be dancing happily because you're doing things the right way. But if you go out and you do it on your own and you're not licensed, I'm going to lose it. You understand? All right. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I will send it to this agreement. Good luck to you, sir.
Thank you very much, Judge.
Judge, we have a,
Mr. Garcia?
no,
Okay, all right. Good luck, sir.
Mr. Sullivan, I have a case with Mr. Dixon. For Sullivan, there was a PC.
On Miss Loyola, this is the young lady that a few days ago you took into custody because she picked up a new case while she was out on our bond.
Right, okay.
She had the felony case. The felony's reset. She's here for her, I guess, arraignment on the new bond. But I think you had already modified her bond conditions 2 days ago. So,
Come up, Miss Loyola.
we do need to talk about some driving issues though, Judge. So
She doesn't have a license. That's the issue. If I remember correctly, right?
I think, you do have a license.
I was working on getting it fixed. It was, not an
If you don't have a license and liability insurance in your name, don't drive. It's as easy as that. If you get your license, then we can talk. But until that point, I don't care what you have to do. I don't care what baby needs picking up. I don't care. You cannot justify getting into a car and driving unless you have a Texas driver's license and liability insurance in your name.
I was
You-
working on getting it.
Okay, working on it doesn't mean that you get to drive because you're working on it. No driving until you have a license in your possession. If I find that you do, I can have a contempt hearing, and every time you drive hereforth, it's up to 6 months in jail and a $500 fine. If you pick up a fourth case, I'm going to lose it. Do you understand? All I'm asking you to do is follow the law. I'm not asking you to do Pythagorean's theorem. Okay, we'll give you a normal setting. Well, actually, no, we won't. The assault's at nearly 200 days now. Is this your case, Sebastian?
Yes, it is. I just,
Discovery complete?
I believe it is, Judge. I'm trusting.
Judge, it's the problem is it's the same transaction out of the felony court, out of the felony case. So I've tried to reach out to her felony attorneys. She tells me that it's bad communication with that particular person. So I'll have to try to really hard to find out because she's hoping
Right
that.
here.
Yes.
Mr. Gould, Mr. Gold was here. That's the lawyer.
Yeah, I saw him today. I
Did you
spoke to
speak to him? And does he know the,
Yeah.
okay, so I guess he knows the situation.
I tell you right now, Judge, I just. As far as the assault, the only thing is that there's some CPS records. I still don't know if the case is closed because obviously they don't give it to us until the case is closed. But apart from that,
I mean, does that really come in this case anyways?
it can. There, I mean, so typically the things that would be in there is typically they do an interview with defendant, they do an interview with kids.
I mean, unless it's relevant, I don't know, but.
Yeah.
Um,
I mean, but you are right. I mean, it is a case by case basis.
Can you tell me when that felony's reset to?
Felony is reset to the 21st.
and is there an offer in the felony case?
I believe the note is, I mean, essentially the offer upstairs is that if she takes something on the misdemeanor, then we'll get rid of the felony.
Okay, so they're set for 4/21. I'll give you the same day after the day it's clear trial here.
Gotcha, 421, Judge?
21, right?
Is there any
I would
way
imagine that's probably a global offer for everything.
Can we go 422?
Sure.
Okay.
But then she'd be coming that day and then the next day. She's on bond.
Right, I got you.
It's up to you.
But hopefully I'll talk to her. If we can get the deal together, then I might just bring her back before then to get it done.
Okay, but after that setting goes clear trial.
I got you.
Got it. All right, John.
Thank you, Judge.
Leaves you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Has probable cause has already been found on this, right?
Yes, Your Honor. So she, it's already been found, but this case is really old. She didn't come to court. So this is kind of, she got rearrested for the same charge.
Okay. Where's this from? If you don't mind.
Your Honor, I'm sorry, I did just
Needs.
Eves.
Need. N.
Yeah, thank you.
N-I-E.
Your Honor, the offense date was October 11th, 2023.
Where from though? With that one.
Oh, where? I apologize.
Walmart.
It was Walmart, Your Honor.
Okay. Can you look to see if discovery is complete?
Yes, Your Honor. It does look to be
1,200 days old. That's more than 3 years this theft case has been hanging around. Old cases can be tricky. Memories fade. Evidence can weaken, but the ankle monitor. That's the court saying, we're watching you closely until this is done.
complete, although we'd have to talk about the videos. Yes.
Well, just to get this case, because they already had a prior PTI offer, which you're supposed to do an anti-theft course. They just reinstated the offers. They said that they'll still take the offer.
They said that they're going to keep the offer.
I spoke to them this morning.
Okay.
So she's going to complete this class this week, and I'm going to send it to them for dismissal.
Okay. This case is 1,269 days old. I'm now putting a monitor on your ankle so I know where you are at all times. You have 2 weeks to get this class done. If you don't, I'm going to set your case for trial. Do you understand?
Yes, sir.
You get no more resets after that.
Okay.
Okay. All right.
Thank you, Your Honor.
So Felicia, if she can get today, please. You are Mr. Vasquez Lechado.
Yes.
Sir, you're charged with driving while intoxicated, facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 21 days in jail with credit for the 7 days that you have done. You're pleading guilty to this offense and it is now going on your record. You need to understand that from now on, facing a minimum of 30 days in jail for any new cases that you pick up. If you ever get pulled over from now on, officers will look at your record. They'll see a prior DWI. If they smell alcohol or dope on you, it's probably not going to go well. So from now on, I would never, even if you have a sip of alcohol, don't get into a car and drive. It's probably not going to go well for you. You're giving up a lot of rights by entering into this agreement. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it goes on your record. It'll be there forever. Is this what you want to do?
Yes.
You plead to the offense guilty or not guilty?
Guilty?
I'm going to find you guilty. I will follow the agreement, send you to it. I'm now going to suspend your ability to get a driver's license for 90 days. Do not drive until you get a license. And good luck to you, sir. Thank you.
And Your Honor, if I may
Sorry,
mention, well, I did want to mention something else, Your Honor. This was a case that I was appointed to maybe like 2 days ago. I did speak to Mr. Vasquez to let him know that not all the evidence is in and that he does have the right to that. He has been in custody since January. He got transferred to ICE, which he says he no longer.
So-
wants to wait for the evidence.
You need to understand that not all the evidence is in this case. By getting all the evidence, it's very possible that she may have a chance to fight your case and beat it. Once you plead guilty, there's no turning around. You cannot come back and return this like you don't like it from Target. Do you understand? Do you want more time to fight the case or do you want to continue with this plea?
I'm fine like this.
Okay. All right, I'll make a documentation that
Thank you, Your Honor. I appreciate that.
it's against your
Yes, Your Honor.